Welcome back to the Texas Appellate Law Podcast. I'm Jody Sanders.
And I'm Todd Smith. Today we're going to talk about, I don't want to call it a nuclear bomb, Jody, because we've seen it coming, but we have a really large change to Texas Supreme Court practice on the short horizon, I would say. And that is the changes coming in the petition for review in merits briefing process. We talked about this a little bit. Well, it was preluded by our conversation with Justice Evan Young. I think it was in August of 22. Justice Young came on and we talked to him about some things that the court was looking at and from sort of a broad perspective on the petition for review process. Justice Young highlighted some of the flaws in that process for us in that conversation. And since then, the Supreme Court Advisory Committee has taken the Supreme Court's charge from earlier this year, I think it was February, to study the issue and to make recommendations for rules and procedures that essentially eliminate the court's practice of requesting merits briefs before granting a petition for review. Back in October, the court dropped miscellaneous docket number, which we'll link in the show notes to this episode, laying out those potential rule changes. That was a result of a lot of work on the part of SCAC. And going back many years even earlier to an informal rules committee that I believe Justice Young talked about when he visited with us. He was on that committee before he was a Texas Supreme Court justice. He was just a practitioner like the two of us at that time. But also on that committee were Justice Brett Busby when he was a Court of Appeals judge, and Melissa Davis, who I believe at the time was the rules attorney at the Supreme Court and has since graduated and is a business court judge here in the division here in Austin. So these discussions, that goes back to the 2010s, I believe, and the discussions about changing the rule. So they've been happening for quite some time. But back in February, the Supreme Court issued a statement that it was going to study the issue and informed SCAC that it wanted proposed rules. And so what we've seen now in this miscellaneous docket order is the result of all of that work in red line and strikeout form to the rules that are affected by this change. So I thought what we would start off with in our discussion today is just kind of how we got here, just a really brief history based on being from the perspective of someone who actually had a law license back in 1997 when the rules were last changed to actually adopt the petition for review process. And then I thought we would just kind of dissect these changes and talk about what we think about them and take it from there. Does that sound all right?
Yeah, that sounds good. And the one thing I'll kind of put up front and we'll remind people at the end, the court's asking for comments on these, and the deadline for that is December 23rd. So if there's anything you hear us talk about that gives you pause or you think could be better in terms of the rules, go take a look at them and feel free to send the court comments on it, because these are proposed but not final yet.
That's right. And we don't want to forget that the court does want comments. And this episode should come out, I believe, on Thanksgiving Day. So there'll be about a month left to make comments. So hopefully folks that listen to this will pull that miscellaneous docket order and the proposed rules and make comments as they see fit. We do know that the court considers those comments very carefully. And we've seen over the many rule changes that have been made over the last few years that those comments have actually resulted in changes to the proposed rule before it goes into final form. So that is a very important part of the process. Absolutely.
All right. Well,
so let me see. Yeah, let me take us back. Follow me, if you will, back in time.
I'm doing the time change, flapping my arms around.
Yeah. So back in the ancient days when I was clerking at the Supreme Court in the mid 90s, the process that was then followed that was changed in 97 to adopt the petition for review was called an application for writ of error. So if you look at your writ histories and cases going back to pre-1997, that's what that refers to. When you see a writ denied case, it was because the application for writ of error had been denied instead of a petition for review, which is reflected differently in cases since 97. And so what caused everyone to want reform back in before 1997 was that every single case going to the Texas Supreme Court required a full merits brief. There was no petition process. It was the application was itself the merits brief. And so anyone who wanted to get their case up in front of the Supreme Court had to essentially prepare a full merits brief to explain why the court had jurisdiction, why the case using the criteria that were applied then, or there were others besides just it was important to the jurisprudence of the state. But that was, of course, the principal one that the court looked at. Conflicts between the courts of appeal and the Court of Appeals were a couple of the other ones. And the parties, I think, got tired of paying lots and lots of money, even in 1990s dollars and before, to have someone brief their issue completely when they had, I think the statistics have held pretty constant over all these years, that the probability of getting an application granted at that time was very low. Certainly less than 20%. It may have even been what we see today, which historically on petitions has hovered between 10 and 12%, I believe. And so the other issue there was that there was a perception that the justices weren't really reading the petitions, the applications, I should say, because you would see, we had page limits back in those days. It was not a word count situation. And the page limits were 50 pages. I mean, I think that may have even been before the 14-point type requirement was adopted. And so they could have been smaller font, 50 pages rather. So it could be a really voluminous document, really dense. And so the way that the judges dealt with that at the time was they all had their staff sort of screen the applications. And the perception there was, well, the judge's eyes aren't really getting on the actual legal work that goes into deciding which cases the court's going to decide. And so the way that the petition for review process was presented was, well, here is a time, here is a vehicle where the promise was that the justices would read every petition. Even before word count, the page limit was 15 pages per petition in response. So the idea was, well, you're going to have this really short document that the judges are going to be able to lay eyes on, and they're going to be able to decide pretty quickly whether it's something they're going to take interest in. The case behind the petition. But it did adopt this second tier, this second level of briefing, which was the actual brief on the merits. And so, I think Justice Young identified these problems in our visit with him back 2 years ago, but there were these sort of perceptions that emerged, such as there really wasn't necessarily that much of a distinction between merits briefs and petitions. They tracked, it was the same issues, the same arguments, maybe a little more developed, maybe some additional authority cited. But one issue there was the court had not yet decided whether it was going to grant review. And so part of the merits briefing process from 1997 to today has been that the court still hasn't taken the case. So you got to have in mind that the court needs to be persuaded it should grant review.
Mm-hmm.
And so that, there was still a lot of argument back and forth, even in merits briefs, about whether the court should grant or deny the petition. Another problem that Justice Young pointed out was that involved staleness. The process took a long time to get from petition for review to merits brief to oral argument to decision, exactly the path that it was on. Some are shorter, but that's the general way that it works. And as Justice Young talked about in our podcast episode, the law can change over that period of time. The lawyer's memory can go stale, and it requires a lot of ramp-up work. Even if you knew the case really well and briefed it in the Court of Appeals, maybe it wasn't quite like starting over, but it did require quite a bit of a refresher to complete a merits brief if the case had been sitting there for 9 months or a year. And then another issue is just the idea of overall waste in the system. Because of the really low percentage of petitions that are granted, 10% overall, 10 to 12%. And with merits briefs, I think that typically has risen to maybe about a third of all cases.
Mm-hmm.
There's a lot of time and money spent on not only petitions, but merits briefs on case that will never wind up coming before the court in a way that will impact Texas law. And so that's something that has been seen as an issue. And then, I think the last one that Justice Young highlighted was that he may have called it a problem of strategic distortion, which, the parties kind of had these incentives that didn't really line up with what a petition for review was supposed to be about. The petitioners could kind of hide behind unbriefed issues and otherwise stay away from issues that made the case look boring. I mean, if you've ever filed a petition for review, and I tell this to clients all the time, the main idea is to get the justice's eyes on it and get them interested in it. And it's pretty easy to avoid the warts in your case if that's the approach you take.
Yep.
So it really wasn't a good or an accurate look at the true merits of the case. So that's, that evolution over time, gosh, it's 28 years now since the process changed. I would say over the last, 3 to 5 years, even going back to the 2010s, as I mentioned, there's been this sort of groundswell of, well, should we change the process? And now with going back to February with the SCAC directive from the court and now this order providing draft rules and also of interest, a procedures summary, which we can talk about.
Mm-hmm.
We're now on the cusp of a really big change. You want to kind of take us through sort of what the change looks like as compared to the petition process, Jody?
Yeah. And I guess the way to start is kind of talking a little bit about the petition process for people that maybe some of our non-Texas listeners or people that aren't at the Supreme Court very often. The way it works, we have a purely discretionary Supreme Court. So you've got to convince them to take your case. And that is done currently with what's called a petition for review, which is a relatively short document, about 4,500 words. And the conventional wisdom from the justices, both currently on the court and that have come before, is really you just want to get our interest. You just want us to think that there is a reason that this case is important. And a lot of times it's what Todd said. There's a dissent, or there's a conflict with some other courts of appeals. There's some, first impression issue that the court really ought to look at. You file that as the applicant. The way it works currently, there's 30 days to respond or file a response waiver if you're the respondent, and the court can't grant the petition or anything without asking for a response. So then that happens, and either they respond and say, you shouldn't take the case, here's why, or they just file a waiver that says we're not going to respond unless you order us. It then goes to the court to review. They get to vote whether they want a response. They can talk about it in conference. So off the bat, you're looking at least 30, usually 60 days before the court gets to look at it. And at that point, if one justice requests a response, they'll send an order out saying, give us a response. The response will get filed within 30 days or longer. If there's an extension, then you file a reply. Then it goes to the court to decide step 2, which is merits briefing. And if they take merits briefing, then you need 3 justices to vote to give briefing on the merits. And that looks like a full-blown appellate brief, which you get, the full amount of words, put in all the issues, address all of the merits. And as Todd pointed out, in the system that we have, there's a little bit of bleed over between the two where you're talking about both why the court should take it in the merits briefing and also why you should win. Once that's done, it goes back to the court, they conference about it, and then they decide whether or not they're going to take the case, set it for oral argument, and decide it, or issue per curiam, or just deny it. And so it is not uncommon that a case will be fully briefed on the merits and then the court will still deny it, which, as Todd said, can be a really expensive and time-consuming proposition, because at that point, it easily could be 6 months to a year from when you filed your initial petition. So that's where we sit today. Now, the new rules have some features that I think are designed to address that, both in terms of cost and time, to make it quicker, more expedient, and hopefully less expensive by not having to go through that whole process to decide it. So I'm just going to kind of run generally through this order and talk about some of the highlights. And the first one is there's no longer going to be this 2-step process before grant. Instead, it starts with a petition for review, and that is going to be the document that the court will use to decide whether or not to take your petition and grant the case. And whereas before you had 4,500 words and you were really just targeting at getting the court's attention as to why it's important, now they've rewritten the rules where you're going to have 6,500 words. So you get an extra 2,000 words, about a third larger, but up to 1,000 of that has to be an introduction that tells the court both why they should take the case and also why you should prevail on the merits. The rule currently has a requirement of an introduction, but it's not quite as focused, I think, and it doesn't have the merits component. Now they've made it clear, we want this to be the first thing. We want you to tell us why we should take it, and you have up to 1,000 words in your word count. So I think that's one of the big changes, both the expansion of the word count and then also the focus on the merits and why to take it. So that's kind of step 1. Yeah.
Do you want to outline all the steps like you did for the petition for the previous process?
Yeah, I was going to kind of do that, and then we
discuss them.
Yeah, that was my thought.
Okay. Yeah, let's do it.
So step 2, the response, they've changed the rule to read effectively, don't file a response. It's not a situation anymore where you have to elect between filing a waiver or filing a response. They haven't said outright you can't file one, but the way that I read the rule, it suggests that you should not file one. They're not really welcome. And if they want one,
Yeah.
then they'll ask you for it. And if you do that, you have to have the introduction. You've got the same 6,500 words. So that alone, I think, is going to speed up the process, because as you get towards the back of the rules and the procedural summary, it's going to go out to the court the Tuesday after you file your petition. They're not going to wait for 30 days. And at that point, the judges can either decide to request a response, which only takes one vote. And if that's done, then they're going to send out the order immediately. So it may be you get an order on your petition requesting a response within a week, which is kind of unprecedented, short of emergency relief. So once you go through the reply stage, then the court's going to have their conference and they're going to decide where to act on it. And in the old days and currently up through January 1st, that meant they would request briefing on the merits. Well, now they're going to decide whether to set it for argument and request briefing on the merits, which will now take 4 votes instead of 3. And you'll know at the end of the petition process whether the court's going to take your case. And we can talk about per curiams in a minute, because that's kind of an exception to the rule. And I'm not sure the rule's very clear on that. But as it is now, if you file briefing on the merits or sometimes just your petition and you don't hear anything for months, then all of a sudden you may just get a per curiam opinion. The rules contemplate that they can still do that. And the procedural summary suggests that in some cases they may do it right off the petition, or they may also do it after requesting merits briefs, but before they grant. So I don't really know how that piece of it's going to work. We're just going to have to figure that out. So that's kind of the broad overview, but we can dig back in with more detail.
Yeah, let's start with the introduction, because that's a pretty big change. Rightly or wrongly, I have tended to use introductions as kind of like the approach you take when you're writing an amicus brief. There was no real firm requirement of what an introduction should be. And so it's been, to me, it's kind of been a vehicle to give maybe a little more practical take on the case and how it could affect not only these parties, but people, subject to the jurisprudence of Texas. And this really narrows that and gives a specific purpose for it than it did before, more so than it ever did before. So I've also heard it said that the intro is kind of like how we were told back in 97 that the justices were going to read all the petitions. Well, the justices are going to read all the introductions. I really think, to me, that seems like that's how this is set up.
I think that's right.
This is your opportunity. And I think this has been said publicly by some of the judges. So I don't think this is any big secret, but this is your opportunity to grab the court's attention, the justice's attention, with why this case ought to be granted, and to encourage them to keep turning the page. And if you're able to do that, then it seems to me that really helps your chances of at least getting a response requested, which I think you mentioned really only requires 1 vote. And so it feels like a monumental thing sometimes when a response is requested, but it's just 1 vote. But still,
well, at
better
least
than
1
a
vote.
denial.
Yeah, it's at least 1 vote. You don't know. That's the thing, but you
That's
at
true.
least got 1 person.
That's right. You don't know. So
Well,
I think the intro to me is it's a very significant change, and I think maybe one for the better. That if you get good at writing the introduction sections of your petitions, that could be a difference maker, I think.
I think that's right. And another change is the rule that we currently have says, well, the introduction really ought to just summarize the reason to grant review. And the rule change says it needs to both explain why the court should grant review and why the petitioner should prevail. So you have to focus both on the reasons to take it and the merits, which is kind of a big change. Not that attorneys didn't do that anyway, but I think now that you have up to 1,000 words, it's going to require digging in a little bit more. So that's kind of the big change on the intro for both the petition and the response. Another
pointed
big
out that I'm sorry, Joe.
No,
You
go
pointed
ahead,
out that
please.
it counts against word count.
Yes.
So yes, you got 2,000 more words, but the court's telling you how to use 1,000 of it. And of interest to those who use their word processor to calculate word count, going to have to change your approach a little bit, because while the intro counts, it's going to be ahead of the identity of parties and counsel, which doesn't count. So it's going to complicate the word count function a little bit.
Yeah, that's a good point. Make sure
The other thing, as we move on, though, I wanted to ask you is, do you think it seems like that response waivers are going to be dead after January 1. What do you think?
I think that's right. I was looking at the rule and it's not completely clear, but they have permissive language in the rule right now that says any other party to the appeal may file a response to the petition for review, but it is not mandatory. They've deleted that, and now the rule is just going to read a response to the petition for review need not be filed unless ordered by the court. It doesn't say you can't file it, but I read that as a very strong suggestion, coupled with the fact that the rule says we're going to present it on the Tuesday following filing your petition, that they just don't want it. Either, I guess if you really wanted to file one, and you cranked it out over the weekend, go for it, I suppose. But realistically, I get the sense they just don't want it. If they want one, they're going to ask you for it.
I agree, but I'm not sure that I see the function of a waiver letter given this new timeline that the court's going to be following.
And they've deleted the language about a waiver in the new rule. So I think that implicitly suggests they don't want it anymore.
So the way to tell members of the public that the lawyer representing you in the Supreme Court isn't up to date on their Supreme Court practice and procedure is after January 1 of 2026, they recommend filing a waiver letter. That's a harsh take, but I think
that's right.
Those of us that are in this court, you gotta be up on this stuff, and you have to know what function does that actually serve. I think it's going to also come down to training staff a little bit, because I'm sure that there are appellate practice groups where if you're a respondent in the Supreme Court, that it's just standard procedure to file a waiver letter. I see it in almost every case. So that'll be an interesting little change in practice.
I think that's right. One other thing in the petition that I think is different and pretty significant is in your issues, the rule requires you to put where the error was preserved with the record citation. And so that's something that has never been a required practice in any Texas state court that I've seen before. So it's interesting that they're taking that on. And the other thing that they have said, and is in their statement here and in some of the comments, is you can't do unbriefed issues anymore. If you have an issue you want the court to review, you've got to not only list it, but in your 6,500 words, you've got to manage to cram in enough briefing to at least explain to the court why it's important and why you should win on it.
Yeah. Again, illustrating the importance of that introduction plus the issue statements. Because if you can't show, and you do see this fairly often, that someone's advancing an argument that wasn't preserved on appeal, or there's an argument about whether it was. And I think it was probably best practice for appellate practitioners. I've seen it happen many times in petitions, or certainly in merits briefs, to show where the error was preserved as a matter of course, and that removes any doubt. So I think it's a good change to require showing that the issue was preserved for review.
Yeah, I don't think it's a bad thing. I think it's going to be interesting, though, when some of the issues arise not really from what you did, but from what the Court of Appeals did, because some of that stuff doesn't necessarily have to be preserved before you bring it to the court. But I don't know how you demonstrate that. I guess that you raised your argument and the court addressed it in a weird way, because a lot of stuff that I take to the Texas Supreme Court doesn't really come up until you get the opinion of the Court of Appeals and think,
I think there's a big difference between stuff like that and, say, a jury charge objection.
Absolutely.
And so I wouldn't be too concerned about straining to show that you preserve your error in the Court of Appeals. I mean, motions for rehearing can raise previously unaddressed grounds if they arise in the Court of Appeals opinion and judgment.
Right.
So I think that would be one way to do it. But, that also, you have to balance that with the idea that you don't have to file a motion for a hearing to preserve error. So that'll be interesting to see how that plays out. But my sense is it's really that really is directed at things that happen in the trial court.
I think that's right. I think you're right. I mean, jury charge error, improper arguments, those kind of things, even legal and factual sufficiency, when you preserved your objections to legal and factual sufficiency.
For sure.
Okay, so that kind of covers the petition process. As Todd mentioned, they gave a Supreme Court procedure summary at the end of this, which is not technically a rule and it's not really commentary. I think it's just sort of the court's best attempt. Up until recently, I think within the last year or so, maybe it was longer ago than that, the court had a pretty robust internal operating procedures paper on its website that's not available anymore. And so I think the Supreme Court procedure summary that's attached to this is a helpful look about how the process works, because people that are in that court fairly frequently know about what they call the conveyor belt system, which is what I mentioned. The petition for review gets filed. You get 30 days to either do a waiver or a response, and then that forwards it to the court. they have to brief or they have to vote. And if nobody votes in favor of doing anything with it, it basically 30 days later, you get your denial of the petition and it just kind of falls off the conveyor belt. And then you can get it pulled off at different stages for the different things. And now it really is, I think, going to change that with the goal of streamlining it, because the summary procedure says the petitions get circulated on the Tuesday following its filing. They won't wait for the filing of a response or waiver for the response deadline to pass before they circulate it. And the goal, it says explicitly, is to help reduce the overall time from filing to disposition.
Mm-hmm.
The judges then have 4 weeks to review the petition and vote. They can either vote to deny, to request a response, or discuss the case at the conference, and then some other options. And if there's no votes other than to deny by the initial vote deadline, then the next orders list, it's going to be denied. If somebody votes to do anything else, it goes on the discussion docket for the next conference. But if there's a vote for a response, it'll be placed on the conference agenda for filing a response, or if a response is filed, it'll be put on the conference agenda after the reply. But the vote for response, like I mentioned earlier, is going to immediately convey the court's order that a response be filed. So really, basically, as soon as a judge, anytime in that 4-week period, votes for a response, the court's going to push the order out. And so the court says that should reduce the overall time from filing to disposition that way too.
Yeah, it's interesting. There's a reference in here to a waiver of response, because it really, again, the conveyor belt is still there, but it's been sped up
Mm-hmm.
considerably. And the whole reason for a waiver of response under the current practice that will be changing was to get the petition sent up to the justices without waiting for that response. And this, under this system, it just cuts off any delay in forwarding the petition to the justices. That is, I think you're right. I think we are going to see petitions being ruled on, at least either you still have to hit that initial, fork in the road where it's something good happens, response is requested, or something bad happens, petition's denied. It's just going to go a lot faster than it used to, I think.
Yep. And for the conference, that all kind of remains the same. I guess one thing that's a little bit different is it used to be at this point that you could have 3 justices request briefing on the merits. Now, 3 justices can request a study memo, which is kind of an internal court staff thing where they dig into the case a little bit deeper. But it takes 4 justices now to request briefing on the merits, because it's the same amount to set the case for oral argument and grant review. So that's now all rolled up into 4 justices. And then it actually takes 5 votes to set an original proceeding like Mandamus for oral argument. So I can't remember if that's always been the rule or not, but that's in here now.
Yeah.
I just don't know the answer on that.
If the old IOP paper were still on the website, we can check that. But I think that's right. I think it has always been the rule, but relying on memory is dangerous.
That's right. No, I get that. So the court, once it's got your petition, the court can set oral argument when it announces the decision to grant. And so this is another change that you won't necessarily get from the rules, but it's practical. Nobody ever files vacation letters in the Texas Supreme Court because it's never really mattered before, because the whole petition process, it's not a situation where there's going to be any settings. Now that the court is going to potentially grant based off your petition, you should file vacation letters, because it's important, because as the court fills out their calendar, and we don't know how quickly they're going to do this, it's going to become increasingly important. And they've actually put that in there. So think about when you file your vacation letters in other courts, do it in the Supreme Court as well if you've got petitions pending.
Yeah, I think that's the importance of that is highlighted specifically in this document. But the reason for that is the court has indicated it's still going to be generous when it comes to granting extensions of time to file petitions and responses, but it's going to limit that generosity. It just comes out and says under this heading time extensions in the document that when it comes to merits briefs, that's going to be limited, because they're going to get merits briefs when they're ready to essentially set the case for oral argument. And, they can't have 3 30-day extensions on a merits brief if they've set the case for argument 60 days out. And so I think this it's going to tighten up when a case gets to the merits briefing stage. It may change the way that some appellate lawyers run their practice who are in the Supreme Court a lot. And starting with, I think you're right, the vacation letter, which I don't think I've ever filed a vacation letter in the Supreme Court.
Well, there really hasn't been a need, honestly, before now. So I guess let's talk a little bit about briefing on the merits. Briefing itself hasn't really changed that much, except that they explicitly have deleted the requirement of a statement of jurisdiction, which I think is sort of a clear signal to those of us who practice there They don't want to hear about that anymore because they've already taken the case. So it really, truly is more like just your merits appellate brief that you would file in a court of appeals. Obviously, the issues have a greater statewide importance and you want to deal with that, but they don't want to hear about why it's important anymore. They want to hear about what the right answer is, why they should rule for you. I mean, that I think is the big change. And same thing for the response brief. The other
Yeah.
thing to think about that's changed here is it used to be that there was a 20-day response deadline in briefs on the merits. They've moved that up to 30 now, which is nice because I never really understood why it was so short for a longer brief. But
No, 20 days is a very short period of time in appellate practice.
it
So
very much is.
I agree. That's a good change.
Yeah, and especially if they're going to be setting argument and not giving as many continuances for merits briefing, I think the extra 10 days is a huge difference.
Let's see. What else?
The per curiam process is interesting because, like I said, now in Texas, 6 justices can vote to dispose of a case on the merits in an opinion without hearing oral argument. That's per curiam. That is typically done now at the end of the merits briefing, but before setting it for argument. So you just have a case that's fully briefed that just kind of sits out there for a couple of months or a few months with no answer, and then you suddenly get an opinion. In recent years,
It can be a lot longer than that.
no, it can. But in recent years, the court's even actually done a few of them straight off the petitions. It's not entirely clear what's going to happen there. They say they can issue a per curiam without requesting merits briefing, and they can rely in part on the Court of Appeals briefs, or they reserve the authority to order merits briefing before issuing a per curiam opinion. And basically they've said, look, we're leaving Rule 55-1 the way that we're going to keep it because we need some flexibility in handling per curiam opinions. And we may want to ask for merits briefing before we grant reviews. That's going to be an interesting one. I don't know
For sure.
what's going to happen there, but that was one that kind of caught my eye as something that's a little bit different that we just don't really know yet. So it very well may be that's here and there in certain cases, either you don't get anything other than a per curiam opinion off your petition, or you get a merits briefing request before the court actually grants it.
Here's what I think could happen. I think this opens the door to more error correction in the PC process. I think if the error is that clear, if it's clear from looking at the petition and response and referring back to the Court of Appeals briefs, then, I mean, logically, it makes sense to me that you wouldn't need to go through the whole merits briefing process to get to a PC opinion, which is kind of, it's the major historical use of a PC. Just it's
Right.
not changing the law or adding to it. It's just applying what are supposed to be settled legal principles to the case before the court. And so that's been an ongoing topic of discussion, I think, among the appellate bar and judges is, well, at least in my view, should the court take on more of an error correction role? Because courts of appeals make mistakes.
They do.
And, I don't want to attribute any ill will or motive to any court of appeals in our state or any judge. It's like Vegas odds. You can dispose of the case in the Court of Appeals, and the chances are pretty darn good that the Supreme Court's not going to do anything with it.
That's right.
And so I think that actually hurts. A wrong decision is overall mostly bad for Texas jurisprudence. Causes a lot of confusion, causes people to have to spend a lot more money fighting about it. Personally, I know the Supreme Court, discretionary jurisdiction, it wants to take cases that are important. Fully support that, but I would love to see this turn into, if you've got a Court of Appeals opinion and judgment that are just clearly wrong, and the court can tell this based on those limited materials, then I would support a reversal and whatever the outcome is, rendition, remand, based on a PC.
Oh, I do too.
Now, the flip side of that is, boy, I'd sure like to know that the court was going to go back and look at the Court of Appeals briefing, because maybe I'd like to say something about that.
Yeah.
So this is kind of the Wild West of, PCs are kind of the Wild West of Supreme Court practice. So that has sort of always been the case, but I think it's even more the case now that we've got these changes that add a lot more wiggle room than what the court does with PCs.
I think that's right, which will be an interesting area, because I hope that they take that as an opportunity to maybe take some more error correction cases. Because, when you're only taking 100 cases a year out of probably 1,000 or 1,200 that come to you, those are pretty low odds. And if they had a little bit more robust PC docket, that's not the worst thing for everyone.
It's really not. If they could do it efficiently too, without committing all the resources to full briefs and study memos and all that stuff,
That's right.
I think that would really be a plus.
And to your point, sometimes the error is pretty apparent, and you can summarize it pretty succinctly in a petition for review or a Mandamus petition that doesn't need a whole lot of elaboration. I think
Okay.
that's kind of the highlights. Looking at my list, I mean, there's some other little things sprinkled in there to deal with it. Same rules in Mandamus now. An original Mandamus proceeding, you've got 6,500 words. You've got to have an introduction. You don't have to have, in your introduction, you don't have to explain why the court has jurisdiction for the case, because it has jurisdiction, but you need to have a reason to grant relief. So it's a little bit more like a merits brief in that respect. Same stuff about responses there. What's one thing that I would point out is in the Mandamus rule, there's no response unless it's ordered, which has kind of always been the case. I wonder how much they're going to start asking for responses in Mandamuses, if it'll change the amount or not.
Yeah, I noticed that there has been that overall change in terminology in the new orders. That used to be that responses were requested.
Mm-hmm.
And now the word request is struck out and the word order is included throughout the rules. And that applies to merits briefs, order by the court. Brief on the merits must not be filed unless ordered rather than requested by the court. I think it's interesting that the court is taking on a little more of an authoritative tone. I think everybody understood that if the court requested a response, you best file a response.
Right.
But that's that sort of thing I've noticed, and just this sort of stylistic change within these rules. I have a couple of kind of follow-ups.
Yeah.
Actually, a few that we can hopefully discuss, and maybe that'll help us bring this whole discussion home. One thing I see in here that didn't exist before is a 2,500 word count for motions, other than motions for a hearing. It's always been kind of a quandary. It's like, okay, you're doing your certificate in a motion, but it's like, wait, what's the word count limit on motions again? Well, there isn't one.
That's right.
So up until now, and so actually, for those of us that don't have a word count in our form or our motion templates, well, you're going to have to put one in, unless it's I think a motion for a hearing is accepted from that.
It is.
So that is probably a good thing. So that was something that stood out to me in these changes. Something else that has popped up is, the rules are intended to go into effect January 1. We won't know for sure until the Supreme Court issues its final order. And with recent rule changes, that effective date has kind of moved sometimes. So they may not actually go into effect January 1, but I think we should all plan on them going into effect January 1. And that raises the question of, well, the new rules only apply to petitions filed on or after the effective date, right?
Mm-hmm.
So if you like the old way, do you hurry up and get your petition filed? Or if you like the new way, do you gamify things a little bit? I hate to say that, but and try to get your petition filed after January 1, or as you and I were talking before we started recording, Jody, if you need to take up a Mandamus petition, which has no actual deadline in the rules, do you just wait till after January 1 to do it? That's a complicated question, I think. And so I don't think we could offer any ready answers there, but that's a strategy call.
No, and I really do feel
make.
for people at the court for the first 3 to 5 months of next year, because they're going to have some that are running under the old petition process, some that are running under the new petition process, and everything in between, and trying to figure out, okay, which one gets a response waiver versus automatic response. And I feel like that's going to be a hot mess.
For sure. That'll definitely take some time to work through all of that. Let's see. Well, let's think about what questions that we've talked about from time to time were not answered in this order or in the procedure summary. The court still, even though it's moving clearly toward a certiorari type model, it still hasn't said that it's going to grant review of specific issues like the Supreme Court occasionally, the U.S. Supreme Court occasionally does. So that's still out there as something that the court hasn't decided to adopt yet.
That's right. And actually, the day these came out, I happened to be at a CLE where Justice Busby was speaking, and he said that these rules were specifically not intended to do that. And so they're still going to, I think, take up the case as a whole, because to his point, and I think it makes some sense, is sometimes you get into the record on this other issue and realize this is actually the more interesting issue, even though at first blush it may not have appeared important. So, trying to make that decision off the petition for review, I guess they're just not quite ready to go that far.
Yeah. I also note that even though we talked about January 1 as kind of being the hard date, the court left itself an out by including in here that petitions filed before January 1 could be ordered to be handled under the new process. I don't know what circumstances might justify that, especially it's going to be enough, I think, for the clerk's office to try to manage two
Oh, God.
systems for a while.
No kidding.
I think the next year, I mean, 2026 is going to be a year of transition
Definitely.
for the Supreme Court. We're going to see a lot of cases that are handled under the old way, and then leading into those that are handled under the new way. So that's going to be interesting to watch. I'm curious about why the court might order a petition to be handled under the new system, other than just trying to move things into that system. That
Yeah.
might be a good enough reason.
I don't know, but I feel like they have to tell you before you file it, because otherwise, how would you know what your word count and introduction requirements are?
I think you're right. Maybe, yeah. When would they tell you?
Hmm.
The only way they even know it's coming is if you file a motion for extension on your petition deadline. So,
That's right.
I don't see how the issue gets raised, or either when there's a motion filed to extend the deadline, the court can say, well, all fine and good, we're going to extend you, but your petition, if you file one, is going to be handled under the new procedure.
Yeah, maybe so, or
That
maybe it'll be some
I
other
don't know. I
other
just don't know.
administrative order. I'm not really sure.
I'm trying to see. I think Jody, that pretty much covers the waterfront on this. And I look for, we're going to have lots and lots of discussions going forward
Oh, absolutely.
about this. And I look forward to having some of the justices on to talk about how the process is going once they get into it. But in the meantime, I think we ought to remind everyone again, the public comment period for this is open until December 23rd. So get your comments in if you have strong feelings about how this works, including, one area would be, hey, court, we'd love for you to take on a little more error correction if you're going to have this kind of flexibility in procuring practice.
Absolutely. One last technical thing I noticed in my notes before we sign off, in both the Mandamus rule and the petition for review rule, where it lists out the contents of your appendix, they now say it has to be in this exact order, which is something that I can see them starting to kick briefs for. So just make sure that you actually follow the order of the rule when you put your appendix together.
I noticed that too, and I think that's a good change. I think as a general matter, I already did that.
I did too,
Just
but
because I thought the court had expressed a preference by the way that it listed those things out before. But I do think it's good to have that clarity. And I hate to see the Supreme Court kick briefs on that kind of technicality, but there's a reason.
That's right. Well, and it's
There's a
just
reason
good to
why the
know that
court said so.
that's the requirement. So starting January 1st, make sure your appendix follows the order.
Yeah. So I would just commend, we talked a lot about the Supreme Court procedures summary attached to number 25-9092. That's a really good place to start. Obviously, you can look at the red lines and the strikeouts and you get a sense of what the court's doing here. But, with all the rule changes we've had over the last few years and even going way, way back, I don't remember the court ever putting out a statement like this.
I don't either.
And I think it's helpful.
I do too.
One thing that it does, though, is it kind of assumes a level of knowledge about the court's internal operating procedures that people who haven't been around practicing doing this kind of work for a long time may not have. And I'll just say I miss the IOPs being on the court's website. That was a very useful paper that was published there. And, just for my purposes as someone who practices in that court, I really would like to see that come back.
Yeah, it is a helpful guide.
I am in favor of as much transparency. Be transparent unless there's a good reason not to. And I don't see the purpose, frankly, of, okay, maybe that paper is outdated, but it can be updated and court staff can help with that. And, the court puts out a Supreme Court case summary paper and maintains it. This is kind of similar to that. I mean, tell us, and this is helpful. Don't get me wrong. And for justices who are listening to this, bravo on the Supreme Court procedure summary.
Absolutely.
But let's expand on this and make sure that people don't trip over anything unnecessarily. And one way to start that is to publish your IOPs on the website again.
Agreed.
All right. Well, that's my soapbox speech for the day, Jody. You got
No,
anything
it's
else?
no, I don't. But hopefully this is helpful, and we'll see what develops in the next few months, and see what rules actually end up getting put in place in early January.
I could get on my soapbox about why we're not getting oral argument summaries anymore from the court, but we'll save that for another
that
episode.
that can be your fight for another day.
That's right. Okay. Well, I guess that's all we have today. Thanks for listening and spending time with the two of us without a guest. We think that we're probably going to be doing more of this format. So
That's right.
if you've got ideas, things that you'd like us to cover, or if you got something you want to come on and talk to us about that's of interest to the Texas Appellate Bar, reach
Let
out
us
to one
know.
of us and we'll give that consideration.
That's right. And until then,
Well, happy Thanksgiving, everybody.
yep, likewise. Thanks, guys.